Saja Thomas, counsel for the department. Ms. Conrad.
Leslie Conrad, Fostering Solutions, foster care worker.
Good morning, Ariel Berger here on behalf of Mother Samantha Stout.
Ms. Stout, please give us your name so we can confirm you can hear us this morning. Oh, we lost her. She was logged in. Well, the rule is, if you participate with good signal, if you're going to appear remotely. So we'll have to ask her to join us in person next time. She's rejoined us by Zoom, I see. Ms. Stout, can you hear us?
Yes, I can.
All right. Here's your signal is not very good this morning. It's dropping in and out. So hopefully that will allow you to continue to participate, but you're probably going to want to appear in person next time so that you can make sure you can hear and see everything that happens for the hearing. Ms. Heiss, whenever you're ready.
Thank you, Your Honor. I was able to visit with this child in person. He is with his half brothers and their mother in Adrian. All of his needs are being met in the current placement. He is bonded there. He's happy there. He got an perfect attendance award at least 1 month. He might have even gotten more. He's doing well in school. He's very well adjusted. Mother visits from time to time, and the placement is able to supervise that and make sure it's a positive interaction. Same with dad. He is incarcerated, but can make contact. I joined the agency in recommending that we change the goal to adoption in order that a termination petition be filed. Mother just isn't doing services. I'm reminded too that she has been through this whole process with older children, and those children were reunified. So I know that she's familiar with a case service plan and getting things done. And I think she's making a very minimal attempt. If we say that actions speak louder than words, I think she's okay with the child being where she is. She might not say that, but that's what the behavior seems to imply. This child has normal traditions. He's enjoying normal family life, daily life. It's my recommendation that we continue this placement and allow a termination petition to be filed, possibly even heard at our next hearing would be closer to the 15-month mark. Thank you.
Thank you. Testimony this morning, Ms. Thomas.
Your Honor, if I can have Ms. Conrad give her report. Ms. Conrad, you have been the foster care worker for this family for quite some time, correct?
Yes, since the date of the child's placement. Yes.
And today you prepared a court report for this hearing. Is that correct?
Yes. Yes.
And are there updates or modifications that need to be made to the report?
There are not. No. I can add in that Credence just had his annual well job exam on October 12th, and there are no concerns noted, no health concerns, developmental concerns.
Thank you. And can you highlight this? Let me strike that. Do you believe that there is still a substantial risk of harm to the child if he were to be returned to his mother's care and custody today?
Yes.
And can you just briefly summarize what that harm would be? I know that it's in your report, but can you just briefly summarize that?
Sure. Mother continues to be unstably housed. She has no financial resources, has not engaged in any services since November of 2022 when he was initially removed. She did just remark on social media a few days ago that she is attempting to be alcohol and drug free. But that is the first I've heard of that or seen that, and it was just a few days ago. So and no services have been engaged in. So substance abuse continues to still be a concern.
In your report, you note that she was in inpatient treatment for a little bit of time. Was there any benefit to that treatment from your perspective?
She reports that there was. I don't, there are no drug screens that are done by mom. We've not met face to face since February of 2023. So I cannot state with any verification or certainty. She reports that she was there for 3 or 4 days of detox, and that has helped clear her mind and help her become motivated to become substance and alcohol free. And then she mentioned on Facebook a few days ago that she is a few days alcohol and drug free. So it is on her mind. It is a goal of hers. I have no way to verify that it was helpful. She was asked to exit the detox center. She did not complete any programming.
And based on the information that you have, are the risks of harm to the child the same conditions that cause the child to come into care?
Yes.
At the last hearing, it looks like the goal was changed to guardianship and adoption or adoption. Do you believe that that is still the appropriate goal?
I do.
Are there any other services or referrals that can be made to assist mom in overcoming the barriers to reunification?
Well, I would be willing to assist with additional or new substance abuse services referrals if she's interested, hearing her state that she has a desire to be substance and alcohol free. She did have a referral very recently made to CMH as a follow-up when she was exited from the detox and inpatient program. Those services have not started. There was a case management meeting she reports she attended. I do not have any verification because I don't have a release of information signed because I haven't been able to meet with her face-to-face. So I don't have verification that she attended. She states that she did, but these are all entry-level, just starting appointments. And we're talking about another unreasonable amount of time, in my opinion, to have services and programming provide benefit when this child's already been in care for a year.
In your report, you recommend the goal change to adoption. With that being said, there's also the acknowledgement that there's a non-respondent father in this matter who's currently incarcerated. Have you had the opportunity to speak with him about his opinion or the permanency of his child?
I have not in the last month, but previous to that, each month when I did speak with him, he reiterated that while he is incarcerated, the best option for Credence is residing with his current relative caregiver. And the caregiver reports that she speaks to him and he would be willing to consider some alternate permanency for him if it looks as if he's going to remain incarcerated. The issue is that his criminal proceedings could continue for quite some time while the child waits in limbo. But I will absolutely schedule a video conference with him in the Lenawee County Jail and discuss his willingness to either look into a limited guardianship that he consents to or voluntary, if he is interested in voluntary release of parental rights, or if neither of those are options he would consider.
Is there anything else from your court report that you would like to highlight for the court's attention today?
I would just like to reiterate that Credence is doing very well for a child in foster care. He exhibits few needs, if any. He is observably bonded to the household that he resides in. He is able to progress in life with a real sense of normalcy from what I can observe and from what I hear from a caregiver and from Credence. And although we are at 12 months and not 15 yet, it is obvious that this child is thriving where he's at with despite the fact that neither parent has had any progress since he entered.
Thank you for that. Your Honor, I have no further questions from Ms. Conrad and would move to admit the court report and the case service plan.
I have no objection.
No objection.
Thank you. It is received. Questions for this witness, Ms. Berger?
I have none. Thank you.
Ms. Heiss?
I have no questions. Thank you.
Ms. Conrad, are you ready to move towards have there been any moves towards looking at guardianship or adoption at this point, like any FTMs or meetings with your staff to talk about what are the next steps?
I've met with the caregiver and have described both options and how they both look to her. And she is very willing to go either route, although guardianship would have to be subsidized for this caregiver, and a limited guardianship that non-respondent father consents to would not provide her with that subsidy. So that is a concern. And because the child is almost six, adoption is ideal for him because he's so young. So I've talked to mother about the idea that this child has been just kind of existing, waiting for someone to make some progress somewhere. She states that she loves where he's at. She knows that he loves where he's at. She's not willing at this point to move forward with any voluntary agreements for permanency. She wants to continue working towards having him back in her care. So that is as far as we've gotten with any kind of permanency discussions. I will admit that I'm a little stymied as to what to do because I was not prepared for father to have been dismissed. And because we don't know, I looked this morning and he is scheduled for a pre-trial and a jury trial in January, February of 2024. I'm not quite sure what to do. If he's convicted, we know what we would do as far as requesting termination and moving forward with adoption. If he's not convicted, I'm not sure what we will do at that point. So we're kind of stuck as to what the best option is legally. I know what the best option is for credence, and that would be adoption by his caregiver. And I know that we would have an ability to present a solid request for termination of mother's parental rights this month.
Well, as far as juvenile guardianship goes, what would the barriers be other than his age?
Well, we would have to prove that there is not an option of reunifying with a non-respondent parent. He would have to be proved unfit for reunification, which incarceration would be part of that. It's just an unknown amount of time.
So basically the same problem exists for purposes of both goals.
Yes.
Okay.
I don't have an answer for you. I apologize. We're kind of in the same limbo, wondering. A lot is dependent on whether father is convicted or cleared. And this could drag on, as you know, for a long time for this child. Ideally, and after having a conversation with father, perhaps he'll agree that ideally it's a matter of releasing his parental rights so this child can move forward with permanency. I'm not sure if he'd be willing or interested in that.
Is the caregiver licensed?
She is not, but she could be.
Because have you been working with her on that at all?
Well, we were not for the bulk of the case because she had a live together partner that had significant histories that would have prevented licensure. They are no longer together. He's no longer living in the home, and we can now move forward with licensure. So we absolutely can.
Okay, Ms. Stout, please leave your device on mute. If you could, please. We're getting quite a bit of noise from your end there. If you can. Your signal doesn't look great. Okay. So have you begun giving her the initial paperwork to fill out or whatever needs to happen?
We certainly will. I kind of wanted to talk through this issue a little bit today because if we're looking at the route of adoption, we would focus on, there are two separate assessments. an adoption assessment is a separate from a foster home licensure assessment. So we just need to do one way or the other. Some of the information is shared, so we can start right away with some of the information that is shared by both assessments. Yes.
Questions based on my questions?
I have none, Your Honor.
Ms. Conrad, there's a hierarchy of permanence goals. Is that right?
Yes.
And would you remind me, adoption is a highly valued permanency goal than juvenile guardianship. Is that right?
Correct. It is ideal.
So then do we have to rule out adoption to get to the juvenile guardianship?
Yes, the juvenile guardianship office, who approves subsidized guardianships, requires written narrative ruling out reunification and ruling out adoption before they will approve guardianship. Subsidized guardianship as a child's goal.
Okay, thank you. That's the only question I have.
Okay. Thank you for your testimony. Any other witnesses, Ms. Thomas?
No, Your Honor.
Ms. Berger?
Ms. Stout, would you like to testify today?
Samantha Stout, can you hear us?
Unmuted. Yes, I do want to testify.
You do or you do not?
Yes, please.
Okay. Deputy Ames, Ms. Samantha Stout.
Ms. Stout, can you hear me okay?
Yes, I can.
Did you hear the testimony of the caseworker?
I've heard some of it. My signal's been going in and out because I'm outside of town. I don't think adoption is not no.
I can't understand what you're saying. You're breaking up.
I do not think adoption is the plan, should be the plan, because my child still wants to come home with his mother. Yes, I've taken longer than expected to get to where I need to be, but sometimes people take longer. I put myself in CMH. I put myself in that rehab. No one referred me to do all that. I did all that myself. I'm doing everything. I'm trying to do everything I can. I have no vehicle right now. All the assistance that they were supposed to give me was never really referred to me since the beginning. So I keep looking through this paperwork that I keep getting emailed to me, and the more I read it, I'm like, none of this was really given to me or resources given to me to do anything. A few things maybe, but I don't have a vehicle. And I'm in a hardship, but I'm still gonna fight for my son. Adoption shouldn't even be in there because he still wants to be with me. Sometimes people take longer. And if you guys can't understand that, I don't know.
Okay. Are you currently employed?
No, I'm trying.
Okay.
I've been trying this whole year. I've been trying to do a lot of stuff, and it's not working right now, but I'm still trying.
Okay. What about housing?
I've been to housing help. They haven't gotten me anywhere yet. I went there probably a month and a half ago. I'm trying to do what I can, and it's hard.
Okay. What daily?
This case didn't even start because of me. This case started because of my kid's dad, and now it's just dismissed, and now I got to deal with it. If I had my son, it would have went to Toledo in the beginning. When I asked them, they said, "Can you take your son?" I said, "Can I take him to a family shelter in Toledo?" No, that's not safe. I would have been housed in Toledo, or I would have had housing, but that wasn't safe. So now I'm stuck doing what I got to do when this wasn't even opened up because of me. It's bullshit. I'm going to tell you that.
What daily steps are you taking to try to get your son back? I
do applications every day. I do job. I I would want a job, and like I say here,
I missed out.
just
None
have
of
a
your
phone.
answers are coming through clearly. Oh, we lost her, which doesn't surprise me given her horrible signal. Okay.
Okay.
Okay. So what daily
Can you
steps
hear
have
me?
you, yep. What daily steps have you taken to try to get your son back?
My son detox. Yeah.
Judges,
Okay, we're done with this. We're done with this. Okay, we're done with Miss Stout. There's no possible way we're going to get her testimony this way. And if she would like to participate, then she can come in person next time. Okay, anybody else you want to try to hear from, Ms. Berger?
No, Your Honor. Thank you.
Okay, sorry. Ms. Heiss?
No witnesses today. Thank you.
Ms. Thomas?
Thank you, Your Honor. I know that my notes indicate that Dad was, the petition was dismissed with prejudice, and I think that sort of ties our hands as it relates to the permanency of this child if he does not voluntarily release. If it is without prejudice and he is convicted, then we can move forward with another petition. But at this point in time, I think that the permanency goal is appropriate as an adoption or guardianship. As relates to mother, there were significant efforts put forth in the beginning of this matter, including a drafting of a power of attorney, case conferences, looking into her sister as to whether she could have been a potential agent for mother, as mother was not housed. She lived with Dad for a little bit. Dad left the house. There were significant efforts put forward to prevent the removal of the child from mother. The fact that she has not made face-to-face contact with a foster care worker in several months is very concerning. And as everyone's well aware, that there's an equal responsibility on the parent to comply with and benefit from their case service plan as much as it is on the worker to provide those referrals. And so at this time, given the lack of progress, the likely diminished bond, mom is not visiting the child regularly, despite the fact that she has access to the relative caregiver and could have those regular visits. We would ask this court accept the termination petition on mom. And as we move forward with other permanency options as relates to the father, I think those can still be explored at the same time. Thank you.
Ms. Thomas, just to clarify, the order entered July 18th, 2023 does dismiss without prejudice as it relates to Eric Young.
Thank you, Your Honor.
Okay, comments, Ms. Berger?
Yes, thank you, Judge. Unfortunately, my client's connection was not the best today. So we do thank you for bearing with the testimony we were able to get. At this time, Judge, we're obviously just asking for more time, that the termination petition not be filed, and that she be given a little bit more time to work these case plan services. As we all know, sobriety is not linear. And it seems that although she does state that she is several days sober, that she still is struggling with that and still struggling with substance use and mental health. And that seems to have put a damper on the rest of the things that she's trying to accomplish. Thank you.
Ms. Heiss?
No closing today, Your Honor. Thank you.
Well, the court finds all interested parties were given notice for purposes of today's reviewing hearing, including Ms. Stout. I do find reasonable efforts towards the goal of adoption and potentially guardianship are being taken. The foster care casework is excellent as it relates to continue to monitor the child for needs, as well as to be available for mothers should she choose to engage in services. And the relative caregiver even continues to be available to mom for purposes of visitation. So I do find our casework, as well as, of course, our guardian ad litem casework to be in satisfaction of statutory obligations there. So thank you, ladies.
Thank you, Your Honor.
Yes. So as it relates to permanency for this child, I would look to the department to decide which route will work, recognizing that the barrier appears to be the same, whether that's juvenile guardianship or adoption. As it relates to the child, it would appear that what is in his best interest is to change the goal to adoption and to order the department to file a termination petition against both parents. In this case, in the name of permanency for the child. Many times, the court is tasked with ensuring that the child's goal of permanency is reached in a timely manner. I also have to balance that against whether or not the initial outset, for example, of this petition, there's an actual risk of harm associated with a parent. So this is a case that has sort of had both of those factors come up at different times. Mr. Young is not clearly a risk at this point to his child, but he is a barrier to permanency in regard to allowing the child to be freed for purposes of adoption. So I will ask the department when they file against mother to also refile against father in order to eliminate that as a potential barrier, and so that the court can realistically look at whether or not, even in the event, for example, he were to be found not guilty and all charges were dismissed, this court would still have an obligation to look at whether or not there would be a risk of harm associated with returning the child to the parent. He's not available to his son at this point. We don't know when that's going to happen, but even if he were at this point for purposes of adoption, I need to look at that piece. So for those reasons, I will ask the department to file against both parents, and we'll set enough time so that hopefully in the event that the petition is timely filed and served, we can entertain the termination petition as it relates to both parents. As Ms. Heiss indicated, this will be at the 15-month time frame. We've been looking at permanency for this child for at least 2 review periods at this point, given the fact that mother has continued to have the same barriers in place, which despite her testimony today, I did include concerns about housing and employment and substances at the outset of this case, in addition to, of course, exposing the child to the risk associated with being in the care of his father, who's been accused of criminal sexual conduct. So for all of those reasons, the child will remain in his placement where he's doing well. That is the safest and least restrictive under the circumstances, as his father remains accused of those serious crimes, as well as incarcerated, and his mother continues to confront the same barriers that she has at the outset of the case, making her, unfortunately, also a continued risk of harm to the child's mental health, welfare, emotional, physical well-being. Our next review, which could potentially, again, be consolidated with the termination trial, will be Friday, January 12th. And we'll schedule that for 2 hours from 10 to 12. And I will look forward to reviewing that petition. Ms. Thomas, if I direct that has to be done within the next 28 days, is that something that can be accomplished?
I believe so. My only concern would be regarding Mr. Young. He had reserved his right to jury trial when we had filed that previous petition, and I would assume that if we refile, that's something he would also want to reserve. And I guess if there's any guidance from the court regarding whether we allow that scheduled jury trial to take place in his criminal matter, I'm willing to do whatever the court believes is most efficient for court resources.
Well, we'll schedule a review and termination as it relates to mother for January 12th. We'll also schedule that for a pretrial for father, is how we'll tackle that, assuming that the petition is filed and served, and we'll reserve a trial date for him. I don't have any time for a jury trial prior to his currently scheduled criminal jury trial anyway. So I think that will probably resolve itself. Once I get the petition, we'll issue some dates in addition to that tentative pretrial date and get that on the calendar as soon as possible. But I can't calendar that until I receive the petition. So as soon as I do, we'll grab some days, probably in February, I would imagine, for purposes of scheduling his jury trial.
Your Honor, on that January 12th date, do you already have a termination trial that begins at 9?
So that's a fair question. I have a note in that calendar appointment that it may potentially be a termination trial if the petition is filed. So I guess the main question is, has that, because I don't know from where I'm sitting, if that's been filed or not, or if that would be filed. And I don't know if Ms. Thomas would be able to give us any update on that.
I don't think it's been filed yet.
And I don't see on my calendar a name on that case.
Orner.
That's literally, it's on my task list for today and will be filed probably by the end of today.
Okay, so, all right. So we'll need the morning for that then, I'm assuming. What I could do is schedule Friday the 19th, starting at 9:30.
I'm out, Your Honor. I'm sorry.
Okay. All right. That's good to know. What days will you be out, Ms. Berger?
The 18th and 19th. One day I won't be the problem.
Okay. Not a problem. All right. How about Thursday the 4th in the afternoon? I have 2:30. I have 2 hours that afternoon.
Works for me.
January 4th?
Yes.
At 2:30, I think we have a review on Carver VC. Maybe not.
It was reassigned to Judge Anselon. I'm sorry.
Thank you. Let's do 2:30 then. Yes.
Oh, we wouldn't be available because we're still on it, but it's with Judge Anselon now.
All right. Is that anticipated to take 2 hours?
If her docket is going smoothly, absolutely not.
Well, I understand what you're saying, however. If it isn't, we'll be waiting all after. Okay. How about, okay, I have an hour on Wednesday, December 13th. And we'll have to simply just schedule a review at that point. And then we'll have to look for some time at the next juncture for purposes of her termination trial, frankly.
What time on the 13th, Judge?
11?
Works for me.
All right, so we'll schedule that for review pregnancy planning hearing. In the event the termination petition is scheduled or is filed and served, then we can at least entertain it for purposes of a pretrial on the 13th. But we'll have a look at that when we get it and schedule accordingly. All other prior orders will remain in full force and effect for all the reasons the court's already articulated. And then unless there's any questions, I'm setting the goal as adoption and we'll move forward accordingly on the 13th.